the appeals, Sequent Nominees Limited and Hautford Limited.
Mr. Rainey, good morning.
Good morning, my lord. It's my lady. May it please you, I appear on behalf of the appellant with my learned friend Miss Gibbons, learned friend Miss Scott, Queen's Counsel, with Miss Black appears for the respondent.
Sorry.
My lord, this claim concerns a property which is a shop with 4 floors above it. I wouldn't accept it's a Georgian townhouse. There's a picture of it in the bundle. At all times since 1986, it's been 75% retail or ancillary. Only the top 2 floors were residential. Those figures can be found both in the judgment at first instance and in the Court of Appeals decision. The decision of His Honour Judge Collender was that my client had unreasonably refused consent to the making of a planning application by the respondent tenants in circumstances where it was accepted by the respondents quite candidly that the purpose of the planning application was to set up an enfranchisement claim. And it's one of the clearest cases of that because there had been a previous enfranchisement claim made with a notice served, a negative counter notice given, and the claim withdrawn. And it's very plain and can't really be controverted that the purpose of the planning application was to make good a scheme where the floor areas were changed. Now, I have to say, of course, that my clients wouldn't accept that getting it to 52%, 48% would in fact get them over any line which there may be. But clearly it would improve their prospects materially. And so the judge accepted. And on that basis, I don't propose, although the cases are in the bundle, I don't propose to take up any time with the rather difficult question as to whether it would be a house reasonably so called. Because in a sense...
a lot of time on that.
This court has spent, and its predecessor has spent...
Don't seem to have clarified it very much, I get the impression.
I wasn't going to suggest that there was any deficiency in the attempts at clarification. As a fact, what is a house has been here, I think, once a decade since 1967. If the Law Commission has its way, then...
Not again in my time, I hope.
Then it won't come back again. Although, I suppose one might say that if my client was unreasonable in withholding consent, you could possibly envisage this case starting all the way back at the bottom and then coming back up. But in my submission, we ought never to get there. And the reason we ought never to get there is because I say that the case is, I hope not too simple, but just really very simple. The purpose of a tenant covenant which prohibits the making of planning applications without consent is simply to protect a landlord from damage to his reversion which flows from the making of that application and, of course, the prospective grant of the planning consent.
Mr. Rainey, you're right to say that the issue, although extremely important, is fairly simple. And although you're both such good advocates that we'd be perfectly happy to spend the whole day listening to you both, if you did finish before your allotted time, don't spin it out.
I don't know quite how to take that, my lord, but I shall endeavour not to. I shall endeavour not to say anything which doesn't need to be said.
Good.
And I appreciate that your lordships have all read 2 written cases. They're not skeletons, they're written cases.
Well, we have.
Indeed, and one doesn't need to go over them.
No, quite.
So, in fact, what I proposed to spend most of my time on my feet doing was to deal with what are effectively, there's certainly one very new point, which is the derogation from grant point. You can see that it might be said to have been foreshadowed in the arguments and judgments of the courts below, but it wasn't explicitly put in that way. Although it isn't the way it was in fact dealt with in any of the cases, what I will be saying is that if that is the key to unlocking the 5th principle, namely that it can be reasonable to refuse consent even where the proposed use is within the user covenant, if derogation from grant is the key to unlocking when that is or is not reasonable, then actually it favours my position. And it would suggest that on the facts of this case, consent is reasonably withheld.
I just ask you if one's looking for the clearest statement of the principle, one might expect to start from the one House of Lords case on the subject, which was Ashworth-Fraser.
Yes, my Lord.
Lord Bingham and Lord Roger
Yes.
summarised the principles. But you don't mention that in your case.
Well, I do. What I do is I set out the principles which were set out in international drilling, and then tabulated them with Iqbal. And then at the end, I did say that in Ashworth-Fraser, both Lord Roger and Lord Bingham had said that 3 of those principles were overriding principles, which are the 2nd, 4th, and 7th from the list. The principles being that the reason has to have to do with the subject matter of the lease or the landlord and tenant relationship, that it's a question of fact. The important point I would submit is in the circumstances as they obtain at the date of the application stroke decision.
But if they're overriding principles, where does that leave the other principles? Underwriting.
Underwriting, well, in a sense, one could say that they are expansions or...
do you need them, is what I'm asking.
Probably not.
It's meant to be a relatively straightforward, simple approach, and the House of Lords approach is that.
Probably not, because the 5th principle, which is on the face of it the most important to the appeal, because it figures so largely in the Court of Appeal's judgment, namely this question about whether you can be reasonable if the proposed use is within the user covenant. That principle could be simply said to be a refinement of the overriding 2nd and 7th, or the 1st and 3rd principles in Ashworth, namely that it has to have to do with the subject matter of the lease, and that it simply has to be reasonable in the circumstances as they obtain at the date of the decision. Perhaps I can go to Ashworth-Fraser now, which is tab 1 in the authorities bundle, the very first case.
Page?
In the hard copy, it's page 5. It's page 333 in the electronic bundle.
Thank you.
I hope that the electronic bundle navigates by tab. I hope I've got...
Yes, it does. It navigates from the index.
Yes, but not linking in the pages, no.
Yes, if you click on the case in the index, you get it on the page. The previous version, well, I'm afraid the electronic bundles have gone through a series of iterations in this case.
I apologise for that, my Lord. It's one of those cases, I think, where with the electronic bundle, if it could go wrong, it did go wrong, and I apologise for that.
It's fine now.
The 2 most important speeches are, first of all, Lord Bingham, who gives the first, which is on page 335 to 336 of the electronic bundle, so far as relevant. Paragraph 3 is the first of the overriding principles, and he does take it from international drilling, but the points which he makes in paragraph 3 of his judgment are these points that the reason has to do with the relationship of landlord and tenant in regard to the subject matter of the lease, and not something wholly extraneous and completely dissociated from the subject matter of the contract. With respect to the respondent's argument, that is not the first principle from international drilling, which says that you look or try and construe the purpose of the covenant, which I say led the Court of Appeal down the wrong track of trying to say that the purpose of clause 319 in the lease was very narrow. The second question or the second principle, which is paragraph 4 of the judgment.
As far as paragraph 3 is concerned, there's no dispute here that's satisfied, is there? It clearly relates to the subject matter of the lease.
Precisely, my Lord, yes. It can't...
Potential of enfranchisement, so that's...
Yes.
So you get home on that one.
I do. And then the next point is the landlord's conduct reasonable or unreasonable is one of fact to be decided by the tribunal of fact. Well, in a sense, standing in an appellate court, that isn't a helpful principle to the appellant, but the factual exercise, which is one of evaluation, it's not a primary factual fact-finding exercise, I would submit, has to be on the right lines. If the court misdirects itself, and I say in my written case, identify a number of misdirections, then an appellate court can interfere. The most important point, though, which I say is implicit in this, is that you look at the facts as at the date of the application. Don't do a sort of a retrospective inquiry looking back in time as to what might or might not have been the case. You ask, what is the tenant asking to do, and is it reasonable for the landlord to refuse on the facts as they obtain at that date? And to digress a moment, as your lordships will appreciate, it is possible with legal changes that the enfranchisement ground might fall away. It might become clear that it is enfranchisable anyway, or the law might change and it becomes clearly non-enfranchisable. And indeed, in the historic cases like Bickle, which we're going to come on to, there presumably was a period of time when the assignment to an individual couldn't have been objected to because there wasn't an enfranchisement act. It only became objectionable when there was an act. So one looks at the circumstances as they obtain at the time. And the third overriding principle is that the landlord's conduct only has to be reasonable. You don't actually have to be right. And importantly, Lord Bingham emphasises the other House of Lords case on the point, which is Viscount Tredegar and Harwood, emphasising that, as he puts it, that one should read a reasonableness in the general sense. What he doesn't do is say that you confine reasonableness by reference to any particular other principle. It's simply, is it reasonable or not? What the Court of Appeal tried to do, in my submission, was to fence around the concept of reasonableness by saying, oh, well, if you go back and try and think what the parties might have had in mind in 1986, it can't now be reasonable. And in my submission, that is the wrong approach. It is subject, as Lord Bingham points out, to the first principle, namely that it has to do with the landlord and tenant relationship, the lease. Once one's got over that, it just has to be reasonable. And there are examples of where a landlord may be unreasonable within those confines, and in very broad terms, the uncovenanted advantage cases could be seen to be that kind of case. For instance, if the landlord is simply trying to, in effect, not preserve the status quo, but trying to change things for his advantage, then that isn't reasonable. But my client isn't falling into that trap. My client is simply trying to preserve the status quo. And it's a submission I'm going to make, I hope, not too long, but I'm going to submit that there are no cases on what's called uncovenanted or collateral advantage where the landlord has failed, where they're trying to preserve the status quo. All of the cases where the landlord's been held unreasonable are where they wouldn't be prejudiced by the proposed change. They're simply failing to gain some other advantage. A common one being that they quite like the lease to be surrendered and replaced by something better. So that's what Lord Bingham said on the point. Lord Rogers' speech in my submission is also very important. If one turns in particular to what Lord Rogers says at paragraph 67, which is page 354 of the electronic bundle. The key points from this paragraph, I submit, are these. First of all, in the third and fourth lines, he explains why reasonableness is, in effect, the test, why it has been adopted in the contract, because it allows the law to respond appropriately to different situations as they arise. And again, Lord Roger refers to Viscount Dunedin's advice in Viscount Tredegar and Harwood that reasonableness is to be read in the general sense. And I submit that that is completely contrary to the notion of confining it. Then he says, Lord Roger says, I've derived the greatest assistance from Lord Denning's comments in Bickle, and he then sets out a passage from the Bickle case. And the key points from this particular passage, I submit, is this. Lord Denning says, between letters D and E, he says at D, the words of the contract are perfectly clear English words. Such license shall not be unreasonably withheld. When the words come to be applied in any particular case, I don't think that the court can or should determine by strict rules the grounds on which a landlord may or may not reasonably refuse his consent. And this is very important. He's not limited by the contract to any particular grounds. So what Lord Denning is saying, and Lord Roger is approving, is that reasonableness means reasonableness. It's not confined by some notion of construing the background contract. Subject, of course, to the first overriding principle that it has to relate to the landlord and tenant relationship. And you can see that made good in the next sentences, nor should the courts limit him, not even under the guise of construing the words. And that's a key point which undermines, I submit, entirely the approach of the courts below. The landlord has to exercise his judgment in all sorts of circumstances. It is impossible for him or for the courts to envisage them all. And then he says, and this is a point my learned friend relies on, when this lease was granted in 1947, no one could have foreseen that 20 years later Parliament would have given a tenant a right to buy up the freehold. Seeing that the circumstances are infinitely various, it's impossible to formulate strict rules as to how the landlord should exercise his power of refusal. Lord Denning there is not suggesting that enfranchisement risk is a good ground because it wasn't foreseeable. He's explaining why it's not a bad ground despite not being foreseeable. Because, as he points out, in the Bickle case, it couldn't have been contemplated that there would be enfranchisement. So whatever the covenant is in the lease, anybody could say, well, if you construe it against the background of the date of grant, no one could possibly have envisaged that you would refuse consent because of enfranchisement. But in fact, that puts it backwards. The point is that reasonable is the ground which is set out in the contract. That is a wide common sense term, and it permits reliance upon things which can't have been in the contemplation of the parties, as well as, more obviously, things which were. And that, I would submit, is the point. In effect, Lord Denning's judgment is being read backwards by the respondent. What he's intending to explain is why an unforeseen circumstance can nevertheless be a good ground. And the reason is because reasonable is wide enough to encompass it.
So you're saying that this reference to, well, was it before the 1967 Act, is really a reflection. There was no risk beforehand, now there would be.
Yes.
To which you say, in parallel, there was a minimal risk presently, but if this goes ahead, there would be a substantial one.
Yes.
Isn't that the way you
That is the way I put
deal with it?
It is. It doesn't. What's happened is that my learned friend is going to submit that there's effectively a black line between cases where the Act, and it needn't be enfranchisement, it could potentially be something like a Rent Act, because we look at the Rent Act cases as well. So he says it all depends on whether the legal right created by the Act pre or post dates the lease. In my submission, it doesn't. What matters is whether or not at the date of the application the tenant enjoyed that legal right, and whether or not the effect of the application is going to be to take them from not having it to having it, or to a substantial prospect of having it. Because if that's the case, then the landlord is prejudiced by the change in the status quo. If the tenant had the right anyway, then the point wouldn't arise. You couldn't possibly say, I don't want you to assign it to this person because they might enfranchise, if the tenant already had that right, because then the landlord is not prejudiced, and they simply therefore cannot say that they have suffered any disadvantage. or will suffer any disadvantage as a result. There are a couple of other points which I wanted to make about what's said in Ashworth Fraser. The first is that I don't know whether it's being pursued, but in some of the old cases there's a difference of view as to how wide the concept of the landlord and tenant relationship is. In broad terms, it's clear from the subsequent cases that the broad view in Viscount Tredegar and Hardwood has been accepted. It can affect other properties retained by the landlord. And I would submit there isn't really any doubt about that, so long as the prejudice results from what's going to happen to this property. The damage, if you like, can be inflicted on a different one. So it can be things like rents on neighbouring properties will be depressed by the use of this property. But I don't think that my learned friend is suggesting any different, and of course enfranchisement relates directly to the reversion on this property. The second point is that my learned friend says that there is effectively a staged process going through, first of all, Lord Bingham's first proposition, then his second, then his third. It may not make any difference to the final result, but I would not accept that. In my submission, there's a single iterative process of whether or not the landlord is acting reasonably. Lord Roger doesn't say it's dealt with in steps. And in my submission, it isn't really very helpful to try and break down stages. It's likely to lead to error. The other point which I wanted to ask your lordships to note is this point about, I have said in my submission that there is a good working rule that enfranchisement is a reasonable ground for refusing consent. Now, I've been very careful, I hope, not to elevate that to a principle of law, which it isn't. But if I'm criticised, in a sense, for saying that there is a good working rule, then I would submit that I am not in bad company, because Lord Roger, in effect, says something very similar at paragraph 74. If one turns over the page in the bundle. What Lord Roger has done in the intervening paragraphs is overruled Killick. We don't need to go into the Killick principle, but he overruled what the Court of Appeal had laid down in Killick. And he says, it's important not to exaggerate the effect of overruling Killick. In particular, it doesn't establish any contrary rule of law that it will always be reasonable for a landlord to withhold consent to an assignment simply on the ground that the proposed assignee intends to use the premises for a purpose which would give rise to a breach of user covenant. While that will usually be a reasonable ground for withholding consent, there may be circumstances where it isn't. Well, I'm not going any further than that. I say that enfranchisement is usually a good ground for withholding consent, but it's clearly not a proposition of law. But good working rules are quite helpful to practitioners at the coalface. And I do say that it is usually a reasonable ground. I give a couple of examples which are actually quite common where it might not be. For instance, if there's a 999-year lease at a peppercorn rent and the reversion is clearly worthless, I don't suppose the court would wish to encourage landlords to be saying, I don't want to have an enfranchisement claim made against my worthless reversion. So that might be a ground, and it would be a ground justifiable on principle, because the landlord wouldn't, in reality, have suffered any detriment.
Was this referred to in the Court of Appeal, Ashworth Fraser? They don't mention it in the judgment, I don't think.
I certainly, I don't really recall very clearly. I probably didn't deal with it in quite the way I've dealt with it now, I think it's probably fair to say.
Nor by the judge, in fact. He doesn't seem to be referred. It's rather odd to find the only House of Lords authority not being referred to in either of the courts below.
Yes, that might be a defect in the way I put it in the Court of Appeal. But the principles, in a sense, the principle which, in effect, drove the Court of Appeal, I would say, against is in fact not answered strictly by simply applying Ashworth, because the one thing I did say repeatedly to the Court of Appeal is, well, what's unreasonable about refusing enfranchisement? We're going to lose the reversion on the property, as the judge, or that there's a reasonable risk of it, as the judge found. What is unreasonable about it? How can you, if you apply the principles correctly, can it be said that this landlord is outside the parameters of what a reasonable landlord would do? And the way the Court of Appeal got there is, while accepting that it's about reasonableness, that they then said, but you have to try and confine it by reference to the purpose of the planning covenant, which is a point I'm going to come on to, this rather slippery concept of uncovenanted advantage. And in my estimation, I really need to deal with that in order to...
That's done by way of construction of the lease. They say you can't just take this clause on its own. It's got to be seen in the context of the lease, and so construing it, you find it subject to a limitation which you didn't find when you looked at 219 on its own.
That is how...
So to that extent, the Lord Denning say, well, you don't try and cut it down by construction, might have been thought helpful to you.
It might indeed, my lord, yes.
But the question of construction seems central to Judge Collender's reasoning in paragraph 61 of his judgment.
Yeah.
Yes, he does. And what he construes it very, very narrowly. And
you'll be telling us that is wrong in law.
Yes.
Yes.
Well, there are 2 points. First of all, I say that he's wrong in 2 ways. He's wrong in the underlying perceived purpose of Clause 319 in itself. And he's also wrong to use that purpose to confine the contractual ground for withholding consent, namely reasonableness. And I've dealt, in effect, with the second of those points, which is that Lord Downing says reasonable is the ground. You don't cut it down in the guise of construction. But I also submit and have submitted consistently, both to Judge Collender and to the Court of Appeal, that the reading of Clause 319, which they've tried to put on it, is simply wrong, because what it does is, and I've said it effectively creates a hierarchy of covenants, because it effectively starts from the proposition that Clause 311 is where you start, and then it's cut down, but only in some minimal way, by Clauses 315 and Clause 319. And indeed, that point has assumed very great significance in the respondent's written case, because the respondents describe Clause 311 as being a grant, and Clause 319 as being a reservation from that grant. And I submit that is completely wrong. Clause 311 is a restrictive covenant. It's a covenant which restricts the use to which the property can be put. It isn't a grant at all. Clause 315, which is a list of other uses which are prohibited, is a further restrictive covenant. And Clause 319, which has 2 limbs. The first is it says that the property shall not be used for any purpose in breach of planning control. That's a restrictive covenant. And then it says that the tenant shall not make an application for planning consent without consent. That's also a restrictive covenant. There's simply a suite of restrictive covenants, all of which have to be given effect. And
is that not rather playing with words, though, Mr. Rainey? Okay, it is restrictive, but there's an exception to the restriction, namely for residential purposes. So that bit's not restrictive.
The way in which I suppose the basic proposition is that if there is no clause at all, the tenant is entitled to use the property for any use at all, as long as it's lawful, because the courts have always implied that it can't be unlawful or illegal. But essentially, it's entirely open. The purpose of putting any form of user covenant in substance, is to restrict what the tenant does. And so I wouldn't accept that the 5 categories of specified use are exceptions. They are merely the things which are not restricted. It's a list of non-restrictions. And I don't think that is playing with words, my lord, because because of the underlying structure between landlord and tenant. They're simply all restrictions on what the tenant can do. I'm going to come on to the derogation from grant argument and whether that explains some of the cases. But what I'm going to say is that it might be possible in some cases, for instance, where there is only a single permitted use, which was the fact in international drilling, to say that, well, you can infer from the fact that there is only one permitted use that that is the purpose of the grant. But where you have, and I don't think this would be disputed, where you have effectively an open user, then you can't say that there is any particular purpose. And so you get cases like the Salvation Army case, the hospital trustees versus Faulkner, where they objected to the use of the premises by the Salvation Army. And that was held to be reasonable because of the effect on the facts it would have on the rest of the estate. Another way you can get at the purpose is with specific evidence. And Iqbal is an example of where there was specific evidence that even though there was an open user, it was intended to be used as a restaurant. So you can say, well, that's a specific purpose from which one shan't derogate. But here you have a very, very wide selection of non-prohibited users. Because it's important to note there are 5 things you can do with the parts of the building. It can be retail, it can be office, it can be storage, it can be residential, or it can be studio, whatever that means. It could potentially, I suppose, be an artist studio, recording studio. I think it's that kind of use that it's probably intended for because there's a restriction on public entertainment. If one thinks about it and thinks about the context of the building itself, these are all of the obvious uses for a shop with 4 floors above it in Soho. So in fact, this is a very wide and open user covenant, and not one which can be used effectively to work back and construe what the purpose of the grant was. But the user covenant itself, I submit, is clearly not the purpose of the grant. And indeed, in the William Hill and Cabras case, which Malone and Friend has cited, if one reads the judgment carefully, the Court of Appeal specifically rejects the proposition that the restrictive user covenant is the grant. It turns on construction of the actual grant, the Habenden, and the fact that it granted pertinent rights. But I'll come on to that point in a moment, if I may, because I wanted to deal quite briefly, as briefly as I can, with limited advantage and collateral advantage. My submission is that the key to that is the word advantage, as opposed to prejudice or damage or disadvantage. And if one understands it in that way, then the principle is quite clear. If the landlord is trying to improve his position over what he has now, then he's going to be unreasonable. If, on the other hand, he is trying to preserve the status quo, then he is likely to be reasonable. I have to say likely because, of course, I'm presupposing that the ground is one which is, on the face of it, a reasonable ground. So the classic example of the collateral advantage is where the landlord wants to force a surrender to obtain possession early. And those are the facts of Bates and Donaldson. And Bates and Donaldson is tab 2, which is page 358 in the electronic bundle. And in a sense, I don't really need to go beyond the headnote because it encapsulates the point quite well, and Bates and Donaldson is discussed in the other cases. It says that the lease, it had a covenant not to assign without license, not to be unreasonably withheld. The lessor withheld the license to assign because he desired to obtain possession, and he then sued for breach. Held, license unreasonably withheld. And the reason that is an uncovenanted advantage, I would submit, is apparent probably most clearly from Lord Justice A.L. Smith's judgment, which is at internal page, sorry for saying the internal page, 247.
Have we not got a more modern example of your point in Bromley Park?
Yes, we do. That was.
Come later.
Well, no, that was the next point I was going to make, because that was my next case. Lord Justice A.L. Smith
Yes.
simply says it's not a true reading of the clause that permission can be withheld in order to enable the lessor to regain possession of the premises before the termination of the term. And the reason he says it is because when the lessor granted the lease, he parted with his interest in the premises for the entire term. So that a lease is a grant of a term of years. If you try and bring it to an end early, you're derogating from grant, is another way to put it, because you agreed as landlord with the tenant that they'd have it for X years. And so that is an uncovenanted advantage, stroke. It's also a derogation from grant, one might think, if derogation is the key to understanding some of these cases. Bromley, as you rightly say, my lord, is a more modern example of it. That is tab 4, which is electronic bundle, page 378. And interestingly, this is, if one looks at the headnote, the fifth and sixth lines, this did involve security of tenure. There was a Rent Act tenant of the flat. The basic facts were that you have a flat with a restaurant below. They are separately let. The restaurant is let on one lease, and the tenancy of the flat above is separate, and that's a Rent Act tenancy. And the Rent Act tenant wished to assign, and the landlord said no. And the landlord had two reasons for saying no, both of which failed. The first reason was, as you rightly say, my lord, was simply that they had a policy that they wouldn't agree to assignments. They wanted to bring tenancies like this to an end. So there's the uncovenanted advantage. There is a second reason which was also given, which was effectively, well, why do you want to kick the Rent Act tenant out? And the answer was because they hoped that the restaurant tenant would take a lease of the whole, which presumably wouldn't be a Rent Act tenancy and would have been on a full repairing covenant. So that was what the landlord really wanted to engineer. And that too is something which is beyond the scope of the landlord and tenant relationship. They're trying to improve their position. They don't have it. And Lord Justice Slade makes the point very clearly on the penultimate page of the case. It's internal page 1034, right at the bottom of the page, below letter H. It's the final two lines. So it says, they, which is the landlord, have not ever claimed that the assignment would actually prejudice them in any way. What they simply wish to do, and there's then reference to two of the cases where, which are in our written case, where it was held that landlord would suffer a detriment. And Lord Justice Slade goes on to say that what the landlord was seeking was a collateral benefit. But that's the point. There's no prejudice from the potential assignment because it would be from one Rent Act tenant to another. So the status quo wouldn't change. West Leighton and Ford is effectively Bromley in reverse, and in that case the landlord wins. And I don't... West Leighton and Ford is in the bundle, but in fact one doesn't have to look at it at this point because there's a discussion of West Leighton in the Bromley case. Lord Justice Dunn talks about it on page 1032, letters E to F.
Can you give me an electronic page?
That'll be 391.
Thank you. Yes.
Between letters E and F, he says, in West Leighton and Ford, the proposal of the tenant had the effect of altering the nature of the letting from a single letting of commercial property with residential above to two separate tenancies, commercial tenancy downstairs and a separate residential letting above. That would have been detrimental to the landlord because the residential tenancy would attract Rent Act protection. So West Leighton is Bromley in reverse, and in that case, the landlord wins. And at letter H at the bottom, having mentioned Premier Confectionery, or Justice Dunn says, in both cases, so that's West Leighton and Premier, the withholding of consent to the assignments by the landlord were held not to have been unreasonable. In both cases, the landlords were seeking to uphold the status quo and to preserve the existing contractual arrangements provided by the lease. In both cases, landlords reasonably believed they'd suffer detriment if the assignments were made. And having then adopted the wide definition of what is the what touches and concerns the landlord and tenant relationship, which is effectively the Tredegar formulation, he then goes over, then says at the bottom of the page and going over onto the next page, he says, there's nothing in the cases to indicate the landlord was entitled to refuse consent in order to acquire a commercial benefit for himself by putting into effect proposals outside the contemplation of the lease under consideration and to replace the contractual relations created by the lease with some alternative arrangements more advantageous to the landlord. So it's status quo versus change, I submit.
Although West Leighton is an invitation to look at the purpose of the relevant covenant, I notice.
West Leighton does have that in there. I suppose it probably should submit that if that is going against what is said or is inconsistent with Bickle, then that isn't the correct statement of the law. The correct statement is the Bickle statement as approved in Ashworth-Fraser. As an alternative submission, of course, what he doesn't say is as to what ascertaining the purpose of the covenant means, because, as I do say, and I apologise for repetition, I do say that the purpose of a planning covenant, or a covenant which restricts making planning applications, is to protect the landlord from the consequences of a planning application. So if that is what is meant by construing the covenant, then that isn't at all inconsistent with my case. And then I probably ought to say something about Holder Brothers and Gibbs, which is tab 5, which is page 395 of the electronic bundle. So if your lordships have that, the facts of Holder Brothers are slightly unusual, can be taken from the headnote. Again, it's an assignment case. The difficulty was that the proposed assignee was the tenant of the premises next door under the same landlord, and they had a yearly tenancy. And so the lessor refused to give consent to the assignment on the ground that he would lose the assignee as tenant of the adjoining premises and that he would have great difficulty in reletting them. And it was held both by the trial judge, Mr. Justice Tomlin, and by the Court of Appeal that consent had been unreasonably withheld. Now, the this, I would submit, is probably close to the borderline of what concerns the landlord and tenant relationship. The best explanation as to why it's on the unreasonable side of the line is on it's internal page 583, which is electronic page.
What are we looking for?
Internal page 583, I'm just having slight difficulty in doing the electronic page. This is not.
Presumably 404.
403 or 404.
It's page 75 in the hard copy of the bundle. It's a second.
No.
Slight IT.
403.
403, my lords. Apologies for the delay.
Sorry, Mr. Rainey, what's the case we're looking for?
Holder Brothers and Gibbs, which is tab 5.
Oh, I've got that, yeah.
Volume 1. But what I wanted to the explanation...
The hard copy from which I'm working doesn't have the electronic numbers.
No.
And so
583.
make allowance for that.
Yes. It's page 75 in the hard copy, or
Perfect.
403.
75.
75 in the hard copy, or 403 in the electronic bundle.
Yes.
And the Master of the Rolls explains the decision by about 10 lines in. He says, you must have regard to the relationship of lessor and lessee inter se, or perhaps may one add to the due and proper management of the property. And he then refers to the Bridewell Hospital and Faulkner case. And then he says, I don't think that the words of the covenant can be so interpreted as to entitle a lessor to exercise the right of refusal when his reason given is one which is independent of the relation between lessor and lessee and is on grounds which are entirely personal to the lessor and extraneous to the lessee. So what he's saying is that, in effect, the damage in that case had nothing to do with what the assignee was going to do with the property in question. The damage was, in a sense, personal to the lessor because it simply related to the loss of that person as tenant on the neighbouring property. So it's probably quite a fine distinction, but that's why it's on the wrong side of the landlord and tenant relationship line.
I thought it was a given in this case that you were entitled to look to the other houses in your Soho estate.
We are, but I think that the limit of it, according to Gibbs and Holder Brothers, was the effect on the other houses in the Soho estate would have to derive from something which was happening to the subject property. So enfranchisement being an example, it's being done to the subject property, use of the subject property, which is Bridewell and Faulkner. In Holder Brothers, the problem for the landlord had nothing at all to do with the use of the property. Presumably he liked the tenant because he had him on the property next door. And the tenant wasn't going to use the subject property for anything which was going to cause the landlord any difficulty. He simply would vacate elsewhere. And that's why it falls on the wrong side of the line.
Yes.
And it's useful to show that because it shows, in effect, how narrow, I submit, the uncovenanted advantage principle is. And then the other uncovenanted advantage point is Anglia and Sheffield, which is tab 11, which is page 465 of the electronic bundle. Oh, my lord, it's the very first case in volume 2 of the hard copy. And this follows on from...
Sorry, could you give me that the electronic page again?
465.
Thank you.
I hope.
That's fine. Yeah.
This follows on, in fact, hot on the heels of the Bromley case, and Lord Justice Slade, who was part of the Constitution in Bromley, was part of the Constitution in Anglia and Sheffield. This was one of those very narrow user covenant cases. The user covenant is set out in the left-hand column in the penultimate paragraph. It was not to be used other than as a travel and employment bureau and theatre ticket agency. And the proposal was to change the use to a building society, as the case name suggests. Now, what the landlord wanted was for it to become retail, because if it became retail, it would enhance the rental values of the properties round about. So again, it's explicable. Landlord trying to improve on the status quo, and one can simply turn to the final page of the judgment, which is page 467 in the electronic version, or page 139 in the hard copy version. Look in the right-hand column, immediately in the middle of the page, there's a paragraph which that begins, such then being the grounds for withholding of consent. And Lord Justice Slade says that the relevant comparison was between the user permitted under the lease and the proposed user as a building society. And he goes on to say that there was no evidence that that would cause any prejudice. What the evidence was that they, as he says, the position on the evidence was the council were trying to take advantage of the application for permission to change use in order to secure a collateral advantage quite dissociated from the bargain, being the procurement of the future user as a retail shop. And he says, it's understandable why they'd have wished to adopt this attitude in the financial interests of the ratepayers, but not legitimate. Logically, if it had been the other way round, if they'd been trying to go from retail to service, then the landlord might have won. Because then they could have said, well, if you go from a retail unit to a building society, that will depress my rental values elsewhere. But you look at it, the facts as they stood at the time. And so in summary, I submit that on the facts of this case, there simply is no question of an uncovenanted advantage. It is as simple as saying that my client has relied on what I would say is a planning ground under the planning covenant. It's relying on the consequences of a planning application for which the tenant requires the landlord's consent. And it is simply, on my side, trying to preserve the status quo. And I submit that there isn't any case where a landlord who's trying to preserve the status quo has been held to breach the collateral advantage principle.
Well, are there any cases on this problematic balance between two covenants? Because that's really at the centre of this appeal, isn't it, Mr. Rainey?
Yes, that's how it was decided below. And no, there aren't any direct cases, which I suspect is why we find ourselves here.
Yes.
But I do say that, in fact, it is explicable and answerable by reference to the established principles. What in effect has happened is, because it is very easy for me to say, as I keep saying, that all I have to show is that my client's been reasonable in the factual circumstances. And the learned friend and the courts below have come up with a number of reasons as to why it wasn't. But I say, well, actually, you should have just stopped and just said, well, was it reasonable? Yes. You know, was my client going to suffer damage? Yes. Does it flow from the landlord and tenant relationship because of the property? Yes.
Well, you better not stop quite there, Mr. Rainey.
I'd better not stop there. Because the way perhaps one way to put it is this. In terms of the hierarchy of covenants argument, it starts from what I say is a false premise. It starts from the premise that clause 311 is the most important covenant in terms of use, and that anything else which is said in the lease about use is somehow subsidiary to it, or is some kind of derogation from it. And I say that that starting point is simply wrong. I say that there are three relevant separate user covenants. as I've said, Clause 311 restricts user outside of 5 categories of use, which I outlined before. Clause 315, which hasn't figured highly in it, but which your lordships will have seen set out in the statement of facts. But if your lordship wants to look at it in its native context in the
Yes, I
lease,
think we should.
I think the electronic and hard copy bundles are the same numbering here, so it's page 257.
257.
257. It should be internal page 14 of the lease, and you should find subclause 15 at the foot of that page. And subclause 15 is a very long clause, but they're all restrictions of one sort or another. So there's a restriction in subclause A about machinery. Subclause B over the page is storage of combustible substances and so on. Subclause C, not to use or permit the demised premises or any part to be used for the noxious, noisy, offensive trades or businesses. You get the immoral user. There's then a sort of fairly Soho-specific restriction on using it as a sex shop or a shop for the sale of pornography. Then you get a restriction on sales by auction, restriction on keeping domestic animals. D is conventional nuisance or annoyance or disturbance. E is the overload, not to overload it. Then F goes back to restrictions on use, which is no exhibitions, public meetings, entertainments or live performances. Then there are further restrictions against betting shop, pub, restaurant off licence or wine bar. So there's a whole raft of other restrictions which I simply submit is that they have full effect. Nothing in Clause 311 overrides anything which is in Clause 315. Clause 311 is a set of restrictions. Clause 315 is a set of restrictions. And then one gets Clause 319, which is internal bundle page 262. Which is in several parts. The first part is an absolute covenant to perform and observe all the provisions and requirements of all statutes and regulations relating to town and country planning. And then a qualified part which says not to apply for any planning permission without the prior written consent of the landlord, such consent not to be unreasonably withheld. And then there's a further set of restrictions in respect of indemnities and some detailed requirements about notices and so forth. But I simply say one shouldn't be looking, and one doesn't look for a particular hierarchy. They are all restrictions. They overlap to some degree, but they all have to be given effect. It's important when considering subject matter and overlap, of course, to remember that Clause 319 covers more than simply a change of use, because planning consent is required for development. Development includes changes of use, but also building operations. So it overlaps with what one might say is the traditional subject matter of the alteration covenant. Whether or not something requires planning consent is something which has to be measured at the date of the application. It may require planning, it may not. In Soho, you require consent to change use from office or retail to residential. In many parts of the country, it's now permitted development to move from office to residential. But you take the particular property and the particular laws as you find it at the time, I submit. So none of this is a grant, and no covenant takes precedence over the other. Now, I did want to draw your Lordship's attention to a point which is made in the Moulton Builders case, which is a case my learned friend has introduced, which is at tab 26, electronic bundle, page 716. And Lord, if I can ask you, first of all, to looking at the headnote, it's an odd, again, it's a rather singular set of facts. It related to a building which was part of the Crown estate. And because of this state of planning law at the time, it wasn't possible for a local authority directly to enforce planning restrictions in respect of a building on the Crown estate without the Crown estate's consent. And to simplify the facts, a flat within the particular block had been let with a user covenant which restricted it to a private dwelling house, first-class club, or residential or professional chambers or offices. And indeed, at the date that the lease was entered into, there wasn't actually a planning regime at all. In 1947, planning came in, and someone converted a flat into offices without planning consent. And the Crown estate gave permission for the local authority to pursue enforcement action. And the tenant complained that that was a derogation from grant. But in considering what was or was not a derogation from grant, Lord Denning, in bundle electronic page 721 or hard copy page 393, made an important observation. This should be internal page 187, and the second new paragraph beginning there is, I think, a short answer. And what Lord Denning says is, when a man sells or lets land for a particular purpose, it is always subject to the proviso that it is lawful to carry on that purpose. Neither the buyer nor the tenant can pray and aid the doctrine of derogation from grant so as to enable him to do something which was something which is unlawful. And then there's a reference to Pullback, Colliery and Woodman. And then Lord Denning notes in the middle of the page, he says, until the Planning Acts were passed, it was perfectly lawful for the lessees to use the suites or flats for any of the purposes. But when the Planning Acts were passed in 1947, it became unlawful to make any material change of use without planning permission. It was not lawful in 1979 for Mr. Dunnett or Moulton Builders to change the use from residential to office without planning. They never got planning permission for that change of use. It was therefore unlawful. Long before the enforcement notice was served, it was already unlawful. But in the context of this particular case, the point which I would wish to emphasise is that far from the planning covenant, which we have here, being somehow clearly subsidiary to the permitted user, actually, as a matter of underlying law, the permitted user covenant is always subject to what is lawful or not, and lawful or not includes what is lawful as a matter of planning law from time to time.
So I thought you said there was no hierarchy, but aren't you there putting forward a hierarchy?
No, I'm not going so far as to say that the planning covenant in effect overrides the user covenant, because that would be to create a hierarchy in reverse. I'm saying that it's effectively a level playing field. Each of the covenants needs to be given effect. It is always, in fact, the case that a user covenant is subject to what is lawful. But for present purposes, it skewers, I would respectfully submit, the notion that the planning covenant in 319 should be taken to be some kind of subsidiary or boilerplate reservation, which is in effect a general words derogation from a very specific grant. I mean, there is nothing in that proposition which I would submit is legally sustainable. It's not a grant, it's not a derogation. They're all restrictive covenants. They all have effect.
You don't need to get into a hierarchy, because 311 itself, by making it clear that there isn't a warranty as to planning status, it surely is making it clear that the user authorised is subject to planning.
Yes, as I said, that is a point I made in my written case, but I say it actually goes beyond it, because I know what my learned friend is going to say. She's going to say that that proviso is a boilerplate clause. So I thought it was worth looking at the underlying proposition, which is set out in Molten Builders, that even without that proviso, even if it weren't there, it would still be the case that the user was subject to planning.
Yeah, but boilerplate doesn't mean that something is pro non scripto. It's been put there for a purpose. Its purpose may be fairly standard, but you understand the clause with its presence.
Indeed.
Yes.
And indeed, I should say, I wouldn't actually accept that. I mean, this is not a standard form set of terms and conditions appended to a specific set of conditions. It is a single lease which someone has typed up, and all of the covenants have, in my submission, clearly been thought about. It's not one of those, as I say, we sometimes get in commercial contracts where there's a piece of paper on the front which says these are the specific terms, and it's subject to the 35 pages of terms and conditions on the back, which may or may not be particularly apposite. So that is effectively it. The one way to put it is that the flaw in the respondent's approach and the approach of the courts below is first of all to treat clause 311 as if it was a grant, which it isn't, but to treat this lease as if there was an unconditional positive promise that without more, all parts of the building can always be used for any or all of the 5 uses in clause 311 for the whole 100 years. And that supposed unconditional broad promise simply can't be extracted from the lease, because it requires you to ignore all of the other covenants and not, in effect, not give them full effect, just not reading all of the words of the contract. That then brings me to the point about derogation from grant, which my learned friend in her written case suggests is the key to unlocking the case. So what is the principle? Well, for that, I would accept that if one's going to go down this road, one would look at Johnson and Holland, which is at tab 21, page 657 of the electronic bundle, or page 329 of the hard copy bundle. And as the headnote notes, there is quite a comprehensive review of the authorities by the Court of Appeal in that case, and it's relatively recent, from 1988. The key points, however, for all the length of the report I would submit, can be extracted largely from pages hard copy 332 to 333, electronic copy 660 to 661. And there are 3 passages which I say encapsulate it. The first is on page 332/660 in the right-hand column under the italicized heading derogation from grant. And the first passage is between letters K and L, which is from a case called Harmer and Jumbil, Nigeria, in 1921. So first of all, we have the point that it's a principle which merely embodies a rule of common honesty. It's fair dealing. And a grantor, having given a thing with one hand, is not to take away the means of enjoying it with the other. So if A lets a plot of land to B, as Lord Lawburn phrases it in Littleton Times and Warner's, he may not act so as to frustrate the purpose for which in the contemplation of both parties the land was hired. The rule is clear, but the difficulty is, as always, in its application. The second passage, which I wish to refer to, is at the bottom of the same page, same right-hand column. It is, in fact, another quote from Moulton Builders. It says, if one man agrees to confer a particular benefit on another, he must not do anything which substantially deprives the other of the enjoyment of that benefit, because that would be to take away with one hand what he gives with the other. And it goes on, that being the principle, the next step is to apply it to the particular factual situation. In a case such as the present, that exercise involves identifying what obligations, if any, on the part of the grantor can fairly be regarded as necessarily implicit, having regard to the particular purpose of the transactions when considered in the light of the circumstances subsisting at the time that the transaction was entered into. So that would be 1986, the date of grant. And then the third of the three passages I wanted to refer to is on bundle page 661 or 333 in the hard copy, between letters E and F, which is another passage from Harmer and Jumbil, Nigeria, which says that the obligation is not on the grantor is not unqualified, because if it were, that which was imposed in the interests of fair dealing might, in unscrupulous hands, become a justification for oppression or an instrument of extortion. The obligation must in every case be construed fairly, even strictly, if not narrowly. It must be such as, in the view of the surrounding circumstances, was within the reasonable contemplation of the parties at the time when the transaction was entered into, and was within, at that time, within the grantor's power to fulfill. So I extract the following propositions. First, if you want to argue derogation from grant, one needs to identify a particular purpose at the date of grant. Second, for there to be a derogation, you have to frustrate that purpose, or at least substantially deprive the grantee of the benefit. Third, it's a narrow doctrine, kept within strict confines, because in effect you have to show that in this case, the landlord is being unfair. And there's another reason as to why it has to be kept narrowly, because the doctrine of derogation from grant could override an apparently unqualified right, because the court would imply a limitation. And the fifth point is that it's a basic principle of fair dealing. So those are the principles from Johnson and Holland. Next question, therefore, does it apply to covenants as such? And I say, no, it doesn't. And you get that very clearly, I would submit, from William Hill and Cabras, which is tab 42, electronic bundle page 974. The Lordships have the case now. Again, I'll try and simplify the facts of it. It relates to the maintenance of signs, which were illuminated signs advising of bookmakers. And at the time, such signs were crucial because of the restrictions on advertising of bookmakers' offices. And what had happened was that the landlord's interest had been sold, and the new landlord said that they had a right to revoke what they called a license to maintain signs, which had been maintained on the outside of the landlord's part of the property rather than the demised premises. And it turns on what is called Clause 3. And if one turns in the report 2 pages on, at the very foot of what will be 648 hard copy or 976 electronic bundle, it says Clause 3 is in the following terms. And turn over the page to 977 or 649. The Clause 3 is at the top. The demise hereby made shall not be deemed to include or operate to convey or demise unto the lessee any right of light, air, or liberties, privileges, easements, etc. So it is what you may call there, it is a reservation or a derogation simply from the grant. The user, or the restriction, it's not really a user restriction, but there is a restriction on signage, which was Clause Roman 15, which is set out immediately below it, which says that no figure, letter, pole, flag, signboard, etc. shall be attached to or exhibited to or on the premises or to the windows so as to be seen from the exterior without the previous consent of the lessor, which shall not be unreasonably withheld in respect of a sign stating lessee's name, profession, etc. So it was a qualified covenant. The reason I say that such restrictive covenants can't be construed as a grant is very clearly made on the next page, which is page 650 or 978 in the electronic bundle. The last paragraph. Having rejected a couple of possibilities which I don't need to ask your lordships to look at, he says that the Court of Appeal then says the judge went on to find a specific grant of the right to exhibit a sign in Tenant's Covenant number 15. There are, as it seems to me, 2 difficulties about that. First of all, the judge's construction of the covenant with the weight which it places on the word to, which is a very strained one, but this is the important point. Secondly, and conclusively, the proposition that a tenant's covenant which prohibits him from placing signs on the landlord's other land without consent can operate as an easement, or the grant of an easement, even in a case where consent has been given before the grant of the lease, is novel and unorthodox, and I have no hesitation in rejecting it. So the court is in fact refusing to find that the restrictive covenant is a grant. The case itself was found in the tenant's favour because there was a specific grant of appurtenances in the habendum. And it was the grant of appurtenances in the habendum which got the tenant home, not the restrictive covenant against signage. So I would submit that it properly understood, William Hill and Cabras does not support the proposition. In fact, it's completely contrary to the proposition that you can directly apply the principle of derogation from grant to the restrictive covenants in respect of user, which we have in the current lease. So
it seems to be something of an off-the-cuff comment, because it doesn't look as if it was contended otherwise, either in the court below or in the Court of Appeal.
No, it appears from the report that it was the judge's own point.
Oh, I see. Right.
And there is, I think, yes, Lord Justice Kerr's judgment, which is at page 654 of the hard copy, which must be, I think it's probably 982 the soft copy, but it's internal page 50. But if you have the beginning of Lord Justice Kerr's judgment, it says the judge was not correct in the conclusion, which he evidently formed unaided by argument, that a specific grant can be extracted from the negative covenant in clause 15. So it appears to have been the judge's own point. But I hope satisfied your lordships that you can't simply apply derogation from grant to the series of negative covenants. I still can't stop, because of course what might be said, and we can see this, it might be said, well, could the principle of derogation from grant apply to the exercise of the consent power under the covenant? And without accepting yes or no, but if that is the argument, that it could be, because derogation from grant is a general principle of law and fair dealing. Well, first of all, is that suggested by any of the authorities? Well, no. But it is a general principle. Could it explain some of the cases? Well, it might, but only if you construe it properly. And that's why I took you to Johnston and Holland. Because the derogation requires identifying the purpose of the grant. So in international drilling fluids, you have a one-use covenant. It may be said that you can try and find a purpose from a single-use covenant. That's really the only place that Millen and Friend can go in this case, because it wasn't run as a derogation case in front of the trial judge, so you don't have a finding of a purpose in 1986. Indeed, you have two quite unhelpful findings from the trial judge. You have the finding that there isn't any evidence of residential use from 1986 onwards. And you also have you had a finding that until fairly recently the first and second floors were used for storage and a staff room. And as I say, the evidence, as the judge said, that there wasn't enough evidence which could sensibly use to support a case that those floors had been regularly used as a residence. So it's not possible on the facts of the case to say that there was a particular purpose known to the parties in 1986 that the relevant floors would be used as a residence. So the only place Millen and Friend can go is to go to the actual covenants in the lease, which she goes to clause 311. And I'd say two things about that. Well, the first thing is that clause 311 is actually very broad. It's restrictive, but it allows for 5 really quite disparate uses: retail, office, storage, residential or studio.
Why is the lessee's situation weaker? Because it enjoys a more general use exception there than just one.
It's weaker for 2 reasons, my lord. The first is that the principle of derogation from grant requires the identification of a particular purpose. And either, I put it in 2 ways, either one simply can't identify a particular purpose from a very broad restriction, or what one might say is quite a limited restriction on use. And that, as I said, this will explain or may explain cases. Or, if one is to infer that there is a purpose, then the purpose is all 5 of the uses, not residential for these floors, because Millen and Friend concentrates on the residential. But no, if there is a purpose which is simply to be taken from the 4 corners of the lease, then it's all 5 permitted uses. And so when you then come to apply the second question about derogation, you say, does what the landlord is doing frustrate those purposes, or substantially deprive the tenant of the benefit of the grant? Well, we're talking about 2 floors out of 6. And we're talking about 1 out of 5 non-prohibited uses. And we're not, sorry, my lady.
It does say that not to use for one or more. So the tenant is entitled to use it solely for one purpose.
Yes, they are entitled to use it solely for one purpose, should they wish. But if one is simply taking the purpose of the grant from the four corners of the lease, the purpose is any or all, perhaps, is the way to put it, of the five. So if one comes to say, well, is there a derogation? Can it be said that what the landlord is doing in this particular case is substantially depriving the tenant of the purpose? To which the answer is, well, clearly not. They can use all of the other floors for the current purposes. They can use the first and second floors for the purpose which was their use at the date of the lease and has been the use ever since. And in answer to another point which the Court of Appeal makes, it's not the case that things won't change for 100 years, because it all depends on the state of planning law and the state of enfranchisement law. So keeping it in accordance with the judgment in Johnson and Holland, and keeping this within the bounds of fair dealing and keeping it within proper bounds, there clearly can't be the beginnings of a derogation argument. It just, as I say, the general purpose of the lease is not conflicted with. And that's why, in effect, does it explain the cases? Well, it explains what is said in United Drilling. Because most of the cases are cases where the landlord has been held to be reasonable, notwithstanding that the use which was contemplated is one of the permitted uses. And United Drilling, which is back in tab 1, is an exception to that general run of cases. It's to tab 6. Which is electronic bundle 409. The headnote shows that the user clause was not to be used for any purpose other than as offices. So it was a narrow user covenant. Now, if one, I know your lordships will have read this because it's one of the first cases, so if I may, I'll just go to the end of the judgment and to page 418, or internal bundle page, hard copy, page 90. At letter D, you should find a paragraph beginning, I'm also satisfied that the judge could and should have had regard to the fact that the proposed service office user was within the only form of user permitted by the lease. And Lord Justice Balkan then says, I've already stated the proposition of law derived from the cases. It may be reasonable for the landlord to refuse his consent to an assignment on the grounds of the proposed user, even though that proposed user is permitted. But it doesn't follow from that in all circumstances it is reasonable. So the question for this court perhaps is, well, where, if at all, does one draw a line? Well, Justice Balcom says, well, in most of the cases cited to us, in which it was held reasonable to object to the proposed user, even though not forbidden, the user clause was in general terms, merely prohibiting the carrying on of a noxious or offensive trade, which is Faulkner, and there's then the exception, which is the Premier Confectionery case, which at the foot of the page, Lord Justice Balcom suggests turns on the particular facts, because the two tenancies were originally granted to the same person. Well, that, pausing there a moment, that one might say is there's a finding of a specific point known to grantor and grantee at the time. But Lord Justice Balcom goes on over the top of the page, at page 419. 91 in the hard copy. I find it difficult to reconcile this decision with the second proposition of law set out above. Well, that's Lord Bingham's first overriding proposition. If it be suggested that it, which is Premier, is authority for the proposition that in all circumstances it's reasonable for a landlord to refuse his consent to an assignment on the grounds of proposed user, even though the proposed user is the only user permitted by the lease, then I'm not prepared to follow it. There's all the difference in the world between the case where the user clause prohibits only certain types of use, so that the tenant is free to use the property in any other way, and the case whereas here only one specific type of use is permitted. In my judgment, in that type of case, it's not reasonable for the landlord to refuse consent to an assignment on the grounds of proposed user, where the result will be the property is left vacant, and whereas here the landlord is fully secured for the payment of rent. Well, Lord Justice Balcombe doesn't anywhere there mention derogation from grant, but it may be that it is explicable on the basis that if you have a single-use lease and the landlord is trying to stop it being used for that single use, then you do cross the line into derogation. Where you don't cross the line is where you have a clause which doesn't restrict it to one specific type of use, where the clause, as it puts it, prohibits only certain types of use. Well, that's this case. The number of uses the number of likely uses for this property which are prohibited is actually difficult to think of, given that retail, office and residential are permitted uses, as is storage and studio. I mean, it doesn't say you can use it as a factory, but perhaps that's not a likely use for a terraced building on a street in Soho. So we fall very clearly on the side of the line which Lord Justice Balcombe would have said is a case where you can refuse consent, notwithstanding that the proposed use is within the proposed user covenant. And why is that? Well, it is possibly because there's an echo there of derogation from grant. And international drilling is the case which has been put forward where the landlord lost on this sort of ground. The learned friend has another point. She makes the point about the Iqbal case that although Iqbal was an open user case, well, as I said before, there was in Iqbal a specific factual finding that A3 restaurant use was proposed, which the landlord knew. So, for those reasons, I would submit that if, as my learned friend says, derogation from grant is a key principle to unlocking and categorising the cases, so one can see when it will or will not be reasonable to refuse consent despite the use being permitted, then, properly understood, the principle assists my client. There clearly could not be said to be any derogation from grant on the facts of this case because, first of all, there's no specific finding as to the purpose. Second, residential was not the actual use of the relevant floors at the date of the grant in 1986, and for what it's worth, hasn't been since. Thirdly, the user clause 311 is not very restrictive at all. And fourthly, if there is and it's an if because I don't accept there's a hierarchy of covenants, but if it is said that there is some conflict in refusing consent under 319 for a use which is not prohibited by 311, it can't possibly be said to be a derogation from grant because it cannot be said that the use of the property for the covenanted uses is frustrated or that the tenant is substantially deprived of it. You can carry on using it in exactly the way you've used it since 1986. You can turn those floors to storage. They can be offices, they can be retail, they could be a studio. It's only as things stand with the delicately poised floor ratios, the state of planning law at the time and the state of enfranchisement law currently, that just at the moment, consent is reasonably refused to planning application. But, as I say, even that presupposes that Clause 319 is subsidiary or is lower down a hierarchy of covenants than Clause 311, and as your lordships know, I don't accept that. They're all covenants restrictive of user, and they all have to be given effect. And in a sense, reasonable means reasonable. It's not to be cut down for the reasons which are set out in Bickle. There's also an additional point which emerges from Johnson and Holland and Littleton and Times Warners, which Littleton Times against Warners Hotels, which it refers to in Johnson and Holland. And although it's not in the bundle, I wonder if I could trespass on your lordship's patience to look at the case itself, which hopefully should have been placed on your lordship's and my lady's bench before we started.
Certainly.
It's mercifully a pretty short case, but it is the Privy Council and a judgment, or an opinion, I should say, of the Lord Chancellor. So it is of some status. The facts are somewhat odd. If one turns to internal page 480, one can see them set out. So this is the Lord Chancellor, Lord Lawburn. And then there's about in 1902, which is the second new paragraph on page 480, Warners Limited, that they owned a hotel in Christchurch, adjoining premises in which the Littleton Times Company carried on business as printers. And then it occurred to Mr. Luttrell, who was a third-party architect, that the hotel could have additional bedrooms which were needed, and the printing house could be accommodated with better premises which was desired if the printing house were rebuilt, so that its business could be carried on the lower floor, and part of the upper floor should consist of bedrooms and be let as such to the hotel. And skipping then to the next paragraph, which is the finding of the trial judge, it says each party entertained doubts as to the wisdom of combining in the same building an engine house with printing machinery and a hotel bedroom, which
Realistic.
Indeed, each party spoke of the risk of noise and vibration. In each case, such doubts were so far removed by the representation of Mr. Luttrell as to his ability to neutralise such risk that I'm satisfied each party signed the agreement in the belief that the noise and vibration, if not absolutely unfelt in the bedrooms, would be so slight as not to be an inconvenience. Only on such a supposition can I conceive two bodies of intelligent and experienced men of business entering into the agreement that they did. Inevitably, Mr. Luttrell turned out to be wrong, and the noise and vibration not only inconvenienced the new bedrooms, but also, because they'd opened up the wall of the hotel, made things worse in the hotel itself. But the key point here is that what then happened is that the hotel, which was the tenant, of course, of the bedrooms above, then sued the printing works for derogation from grant. And on the face of it, one might have thought that they had an argument, because it was known that they were to be let for hotel bedrooms. And Lord Lawburn says on page 481, he says, and this is actually, part of this is quoted in the Johnston case, the maximum grantor cannot derogate from his grant expresses the duty ordinarily laid on a man who sells or leases land. But it doesn't touch a similar and equally binding duty that may in certain cases be laid on a man who buys or hires land. So if A lets a plot to B, he can't act so as to frustrate the purpose for which in the contemplation of both parties the land was hired. So also if B takes a plot from A, he may not act so as to frustrate the purpose for which in the contemplation of both parties the adjoining plot remaining in A's hands was destined. The fact one lets and the other hires does not create any presumption in favour of either in construing an expressed contract. And at the end he says both should be held to an implied common intention. And then at the top of page 482, Lord Lawburn says that the Hotel's counsel argued the case as though the common intention was the plaintiff should have reasonably quiet bedrooms. It was so. There was only one half of the common intention. The other half was that the defendant should keep on printing. One can't bisect the intention and enforce one half of it when the effect of doing so would be to frustrate the other half. Now, in this particular case, a similar point arises. We're dealing with a lease. A lease is a grant of a term of years. My learned friend says, we know I don't entirely agree, and I've made my points about it, my learned friend's essential proposition is that these premises were let for 100 years on the basis of the user covenant of clause 311. Well, yes, but what was supposed to happen after 100 years? Answer, landlord gets the premises back. That is the purpose of the grant of a term of years. The landlord has a reversion. Enfranchisement is the destruction of that reversion. In a sense, enfranchisement is a statutorily authorised derogation from grant in favour of the tenant. Now, you can't sue the tenant for exercising the statutorily exercisable rights, but it is one half of the purpose of the grant of a term of years. So the tenant cannot, in my submission, invoke derogation from grant to justify or to say that the landlord was unreasonable in refusing consent when the purpose of the tenant is to enfranchise, because the purpose of the tenant is to derogate from the grant. To adapt what Lord Lawburn said in Littleton Times, that what is the common intention? Grant for a term of years on specific covenants, get it back at the end. You can't complain if the landlord says, well, I'm not giving you consent to do X, when X is to destroy the landlord and tenant relationship, because that itself would be a derogation. So you can't split the two up. So I would submit.
Is it a bit contrived to say that enfranchisement is a derogation from grant? I think you're saying it's a derogation from the tenant's grant, as it were, that the reversion will operate. But the tenant isn't granting that, really, is
No,
it?
that's right. Your Lordship is right. The tenant isn't granting it. That's the key to what Lord Lawburn says here, is that the derogation from grant principle includes, as he puts it, the similar and equally binding duty that may be laid on a man who buys or hires the land, the tenant. So in this case, the tenant couldn't object to the use of the reversion, because the reversion included the printing works. The tenant can't object to the use of the printing works as a printing works, despite the purpose of the grant to him, because they're part of the same common intention. If the common intention in any term of years is that the landlord gets the property back at the end, enfranchisement is a very peculiar thing, because by statute, it will mean the landlord does not get it back at the end of the years, at the end of the term. The term is extinguished. And it doesn't matter whether the tenant bothers to merge the lease or not. There's no reversion left after you've been enfranchised out. It's gone to the tenant. There is no term of years left. So what the tenant is doing is saying, well, Parliament has given me this right, fine. But what the tenant in this case is doing is saying, landlord, you must not refuse me consent to get into the position of exercising the right to enfranchise, because that, says the tenant, is to derogate from my grant. And I say, if you apply Littleton and Warner's, you can't run that argument. You can't argue derogation on the one hand if you're trying to derogate yourself on the other. One cannot bisect the principle. It's perhaps a slightly different way of the point I put in my in the written case, which is that about uncovenanted advantage. If you use the words of that, the tenant is in fact seeking the uncovenanted advantage because they're seeking to go outside the landlord and tenant relationship by terminating it. And I don't flinch from saying, because I say it is clearly the case, enfranchisement is different from simply something like security of tenure under the Rent Act, because security of tenure merely postpones the landlord's reversion. You stay being a landlord. You still have your covenants. Enfranchisement means you're not a landlord anymore. The tenant has the freehold. It ends, as I say, it ends the relationship. It is the ultimate derogation from the principle of landlord and tenant. And that's the whole point of enfranchisement. Of course, it's a matter of public policy, but it's the government and Parliament has stepped in to say that in some circumstances tenants should be able to step into the shoes of their landlord. So for all those reasons, and there are now a lot of them, I hope, which I've elaborated, the new point about derogation from grant cannot, I submit, assist my learned friend. And we are back, I hope, essentially to where we started, which is that the key point is as to whether or not it is reasonable, the three propositions in Ashworth-Fraser. In the short remaining time which I have allotted, I want to deal with two other points. The first is the argument that enfranchisement risk is only a reasonable ground if the lease predates the relevant act.
I think you've dealt with that, really, Mr.
I have largely dealt with it.
Well,
but,
continue, but anyway.
Yes.
You touched on it early, and I think you realised that we understood the point you were making.
I do. What I wanted to say was my learned friend has introduced two Rent Act cases, and I just wanted to point out that if one looks at those, they don't support this proposition that it matters when the Act comes into force. And they come as a neat pair. I mean, the first is Lee and Carter, which is at tab 23 at page 683. Of the electronic bundle. It's page 355 of the hard copy bundle. Lee and Carter was, as one can see from the headnote, a company-let case.
Which tab, sorry?
Tab 23 in the hard copy.
23, thank you.
It's not uncommon in the sense that it is a property which always would have qualified for the Rent Restriction Act, but it was a company let, and it was occupied by the director of the company. And so as the term came towards an end, there was an application to assign it into the personal name of the occupier, which of course would give them Rent Act protection. And the landlord was held to be reasonably withholding consent, even though, and it seems so obvious I hesitate to say it, but even though, if one looks at the facts of this case, it was always potentially within the Rent Act. And it is an obvious point, but one does need to step back, because the judges below, with respect, at some points, in effect, lost sight of the fact that they were dealing with a mixed-use case. And in mixed-use cases, it starts to sound easier to say things like, you should have restricted properties from being used for residential purposes. But most of the cases which we look at in the bundle, so Bickle and Kitway, West Leighton and Ford and Bromley, this case, they're residential cases. And there are a whole raft of cases where the point is, of course the property is residential. They're a house or a flat. And the question is simply as to whether you can go from a non-qualifying tenant to a qualifying tenant. And it's no good saying, oh, well, if you didn't want it to be capable of enfranchisement or Rent Act protection, you should have prohibited residential use. Well, they're residential properties. So it's a poor point. And so Lee and Carter is the obvious one, but the important one is, having looked at the very obvious one of Lee and Carter, is then to look at Swanson and Fortin, which Malone Trent has also put in the bundle, which is in tab 37, which is electronic bundle 919. And I can take most of what I need from the headnote itself. which says that a dwelling house capable of coming within the scope of the Rent Restriction Acts was demised for a term expiring in 1947. I think the actual term began in 1937. We get that from the foot of the page. But the tenancy agreement contained a covenant by the tenant not to assign the premises without landlord's previous consent and not to be unreasonably withheld. And this is the important point. So it was Rent Act, but then the tenant, having himself gone out of possession, in 1947 applied for the landlord for leave to assign the premises to an assignee who was respectable, etc. The landlord didn't consent to the assignment on the ground that the assignee would, at the expiration of the contractual term, become a statutory tenant. And then the tenant went ahead anyway. And the Court of Appeal said that, on the facts of the case, the refusal was not unreasonable. So, pausing there a moment, you've got a Rent Act tenancy at the date of the grant. The Rent Act tenant goes out of possession, so the Rent Act ceases to apply. But when he then, at the end of the term, says, well, can I assign it to someone who will be Rent Act? The landlord says no. Now, this notion that reasonableness depends on when the act which confers the tenant's rights came into force is completely exploded by those simple facts. What mattered in Swanson and Fortin was that the tenant at the time of the application for permission to assign no longer had protected status. So the status quo has become no security of tenure, and therefore it is reasonable to refuse an assignment which would recreate the security of tenure. And in my submission, unless these cases are wrong, what Swanson and Fortin shows is that it's really the very obvious point. You simply assess matters at the date of the application. Is it reasonable in the circumstances as they then obtain, the facts as they obtain at the time? And it is simply, does the tenant have the rights under the status quo? Will the proposed change, and it could be an assignment, or it could be a change of use or an alteration, will that cause the tenant to have rights? If the answer is yes, then consent is reasonably withheld. Although I'll make this point very quickly, because I don't have a huge amount of time left. Malone and Friend says that all of the cases on enfranchisement are all assignment cases. She's not actually right about that. There's Henley and Cohen. In Henley and Cohen, the tenants did qualify, but the property wasn't residential. And what they'd done was they wanted to change the plan of the property to create a flat. So it was actually a consent to alter case. The trial judge said that consent was reasonably refused because of enfranchisement. I can't rely on the Court of Appeal because it was the one ground on which Lord Justice Lewison refused permission. But that is an example. I can say this much. It's an example of a case where the enfranchisement risk didn't simply derive from enfranchisement. It derived from an alteration. And so I'm
terribly sorry, Mr. Rainey. Can you repeat that? What's the ground in this case?
It didn't arise from assignment, I think you meant to say, not from enfranchisement.
Yes, didn't arise from yes.
Yes.
It's not the case that all, because Malone Friend says, well, Kitway and Bickle are all about assignment.
Yes, quite.
There is one case which isn't, which is Henley and Cohen.
What ground have you not been allowed to rely on?
No, it was. I can't take you to the Court of Appeal decision on it because Lord Justice Lewison.
Oh, I see.
Malone Friend makes the point that you only really have a county court judge on it.
Oh, I see. Forgive me.
But the point is, as an example of a case, Henley and Cohen is at least an example of a case where the refusal context was not simply assignment. In that case, it was alteration because the tenants, Henley and Cohen and Maunder Taylor, who were the tenants, they did qualify, because everybody qualifies these days. What they didn't have was a flat. And so they needed to convert it. And the landlord said, I'm not giving you consent to alter because you'll be able to enfranchise. So as I say, the true position is as simple as I have, I hope, always suggested it is, namely that it is reasonable to refuse consent if the tenant currently doesn't have statutory rights, and it doesn't matter when those rights arose or how they arose. I think I ought to say something, because I haven't said anything at all about it. I ought to say something, at least very briefly, about the other part of the species of damage. The Lordships already know that what I say about enfranchisement is that enfranchisement is not the purpose of Clause 319. Clause 319 is not, quotes, designed to stop enfranchisement. Enfranchisement is, in this case, on the facts of the damage which flows from the planning application, which is why I simply say, is there a planning application? Will it cause damage? Answer, yes, it's reasonable. Enfranchisement is the species of damage, not the purpose or intent of the covenant. But enfranchisement has two effects. In the first is the loss of the reversion on the current premises, but the second is it has the knock-on effect on the properties on either side, which is the point about restrictive covenants. The Court of Appeal and His Honour Judge Colander said that there was nothing in this point because Section 10 of the Leasehold Reform Act of 1967 allows for restrictive covenants to be carried over onto the freehold title. And I just wanted to emphasise one or 2 points about that. The first is the very broad point that freehold restrictive covenants are a feeble substitute for the landlord and tenant relationship. The second is it can't be unreasonable for the landlord not to want to have a fight in the first tier tribunal, perhaps, over the translation of restrictive covenants in the lease into freehold covenants. Because, as one knows, one of the benefits of enfranchisement, which is a subsidiary benefit, but nonetheless important, is the ability of the tenant to take any of its disputes to a tribunal for determination. And then a number of obvious points. First of all, it doesn't allow for any positive covenants at all. So things like repair, redecoration. It may maintain the value of property roundabout if 51 Brewer Street is in good repair and well decorated. But decoration and repair require parties to spend money. They're positive covenants. They can't be translated over. The other point about it is that in order for any covenant to be translated over, it has to be demonstrated on evidence from a valuer that there will be a material enhancement of the value of properties round about, which has to be distinctly proved, not in pound, shilling and pence, but in general terms. Nevertheless, a valuer has to say this covenant, this particular covenant here, will, in his opinion, or her opinion, materially enhance, or at least preserve, the value of properties round about. And my learned friend, I think, in effect says, oh, well, you will simply prove that as a landlord. But the reality is that if one thinks about it, it's not actually easy for a valuer to say, well, the value of number 53 will be lower if there is no control on, and one of the examples in the cases is hanging out washing at the back. It's very difficult to say, well, that a buyer would pay less, potentially, if they didn't have the benefit of it.
It's a very incidental point, this isn't it? I mean, if you win on the main point, you don't need this. If you lose on the main point, you're unlikely to get home on this.
You've dealt with it between 104 and 112 quite fully, Mr. Rainey.
I have. I just thought that I ought not to sit down without saying anything at all.
I think you're right.
But I do take my Lord Carnwath's point that it seems unlikely that if I lose on the main point, I could get home on this. But nevertheless, it does. Given that we are dealing with something which, as I've said at the beginning, it should be an iterative process of looking at the damage, then it is worth taking into account, I would submit. And it simply shouldn't be brushed away by simply saying Section 10 is good enough. Section 10, the proposition is Section 10 is clearly good enough if the tenant has rights, because Parliament said so. But if the tenant doesn't have rights at the moment, then not wanting to get into the Section 10 battleground is a perfectly reasonable stance, I would submit, for the landlord to take. Unless there's anything further.
Seems not. Thank you very much, Mr. Rainey. Well, Ms. Gibbons, your team has run out of time, so this is only really a courtesy inquiry. Do you follow? Thank you. Ms. Scott.
My lords, my lady, I'm just going to set out what our case is in a nutshell. I know that the court has these points, but I will just commence by doing that, and then I'll go on to consider our substantive case.
Thank you, Ms. Scott, and keep your voice up so that
Yes.
everybody, even at the back of the court, can hear.
Yes,
The microphones do not project your voice, they simply record it.
yes, thank you for that. So, my lords, my lady, the landlord in this case granted to the tenant by clause 311 the express right to use the whole or any part of the demised premises for residential purposes. That's how we construe clause 311. On a proper construction of the lease against its statutory and factual background and taking into account the other terms of the lease, including clause 311, the landlord may not deploy clause 319 to prohibit the tenant from using the first and second floors for residential purposes for the foreseeable future. So the only ground on which the appellant objects to the planning application here is that the respondent wishes to make, that the planning application that the respondent wishes to make is that if it were successful, it would allow a change of use to residential use. That's the only ground on which objection is taken. So they're objecting to residential use per se, but they've already permitted such a change to residential use by the user clause. There isn't a restriction in the user clause on residential change to residential use. So in our submission, as you know, we say that that's a derogation from grant. It is also to seek a collateral advantage. I'm just going to deal at the outset with the main thrust of the appellant's case, which is that a reasonable apprehension of harm to the landlord's property interests is an entirely sufficient condition to enable it to withhold consent. That's the way that the appellant puts its case in its written case. We say, first of all, that obviously ignores the principle of non-derogation from grant, with which Mr. Rennie didn't really grapple in his written submissions, but now we have some flesh on the bones of what he's saying about that in his oral submissions, and I will deal with those points. Secondly, although perceived harm is a necessary condition, we say that it's never been the only requirement. It's not the overriding principle, as we know from Ashworth-Fraser, as we've looked at this morning. The landlord mustn't seek an uncovenanted advantage. Now, I'm going to come on to deal with Ashworth-Fraser, obviously. My Lord Carnworth made the point that the way that the uncovenanted advantage point is expressed there is to say that the landlord can't take objection to something that doesn't relate to the subject matter of the lease. Now, obviously, there's a different formulation to that in Bromley Park, which Mr. Rainey took the court to, and that is as follows. It mustn't seek to acquire a commercial benefit for itself by replacing the contractual relations created by the lease with some alternative arrangement more advantageous to the landlord. And that's the formulation that's used in Bromley Park. And that is the formulation that, in fact, Lord Justice Balcombe was using when he set out his second proposition. He refers to Bromley Park, so he specifically refers to the case where it is set out that you can formulate the uncovenanted advantage point as acquiring a commercial benefit for yourself and replacing the contractual relations under the lease with something that's more advantageous to yourself.
Do you have a page number in Bromley Park for that formulation?
Yes, of course. It's page 392 of the electronic bundle.
Thank you.
It's page 64 of the hard copy bundle. It's the formulation used by Lord Justice Dunn, page 1033A of the report. It's page 392 of the electronic bundle.
You say that's adopted by Lord Justice Balcombe.
Well, I say that in international drilling, Lord Justice Balcombe refers in support of his second proposition, which is the no uncovenanted advantage proposition, by reference to Bromley Park.
Yeah, but not that formulation.
May I just turn up international...
I mean, the trouble is with these cases, we've seen a lot of them, and people put things in different ways, and
Yes.
that's why one would normally start with what the House of Lords said as being
Yes, of course.
The guide is in here.
Of course. The point that I was trying to make, my lord, is that what Ashworth-Fraser is doing is condensing Lord Justice Bolcombe's 7 propositions and referring to them as 3 overriding propositions. Now, the first overriding proposition is Lord Justice Bolcombe's second principle.
Yes.
And Lord Justice Bolcombe, in his judgment, drew his second principle from Bromley Park.
Sorry, can you have the page number for Bromley Park again?
Bromley Park, my lord, is page 392, electronic bundle, page 64. So it's volume 1, tab 4, page 64 of the hard copy bundle. So, my lord, I'm going to come on to deal with Bromley Park in more detail and international drilling fluids. At the moment, I'm just dealing with the main broad submission by the appellant that a reasonable apprehension of harm is entirely sufficient, and we say that's not the case. Looking at Ashworth-Fraser, the overriding principle is, in fact, the landlord mustn't seek an uncovenanted advantage. So, my lords, I'm going to come on to deal now with what we say is the correct approach, which is to construe Clause 319 in its context. And some attack has been made on that proposition this morning by Mr. Rainey. And we rely on specifically what Lord Justice Roskill said in Westleyton and Ford in the passage to which Mr. Rainey took you. That's page 460 of the electronic bundle, page 132 of the authorities bundle.
All 60.
460, yes. My lord, yes. So it's at the top of page 605, the top of page 132 or page 460. So what Lord Justice Roskill is saying here is that first of all, he agrees with the observation made by Lord Justice Lawton in the appeal in the Westleyton case. He didn't see that there should be some different rule applicable to Rent Act cases on the one side and Leasehold Reform Act cases on the other side of the line. And then he goes on to say this: I think that the right approach, as Lord Denning, Master of the Rolls, suggested in the Bickle case, is to look first of all at the covenant and construe that covenant in order to see what its purpose was when the parties entered into it.
Pausing there,
yes, my lord.
What is the actual reference to Lord Denning's reference to looking first at the purpose?
So, my lord, I think what's being said is that Lord Denning took the view that one must look at the facts of each individual case, and therefore, in order to do that, one must look at the covenant itself in its context.
Well, no doubt, but I tried quickly to comb Lord Denning's judgment in Bickell for a reference to, well, you start with the purpose, because that's what Lord Justice Roskill said he'd said.
Yes.
And I couldn't immediately, I'm sure it was my fault, locate it.
Well, I think, my lord, as I've said, what Lord Justice Roskill is doing is distilling Lord Denning's principle that one must look at the infinitely various circumstances of the case.
I see.
So,
And
are you saying that Lord Justice Roskill is wrong to say that Lord Denning did say what is said at the top of page 605?
I think he's referring to the approach that he took rather than the words that he used, my lord. So what's being said is the right approach is to look at the covenant and construe it in its context. What did the parties think that the bargain was when they entered into it
I mean, that's one way of doing it, but I think it's quite important for us to know whether Lord Denning did say what he said in Bickle, because it's Bickle and Lord Denning, which is then adopted by Lord Rogers in the House of Lords. So perhaps, I mean, over the lunch break or something, we can clarify with Lord Junior whether that is a fair representation of what Lord Denning said.
Because he did warn against doing something under the guise of construction somewhere in Bickle, didn't he?
He warned against doing something under the
guise of construction.
Yes, but he was referring there to, let me just turn up the page, my lord. He's referring there to not being limited in the construction of the relevant clause. So not even under the guise of construing the word reasonable should you try and put a gloss on the word reasonable. Now, we don't obviously disagree with that. But what we do say is that when looking at whether there's an uncovenanted advantage, the first thing that obviously must be done is to construe the clause and see what the purpose of it is. Because without doing that, one can't then discern whether what the landlord is doing is attempting to act outside of the purpose, and therefore to seek a collateral or uncovenanted advantage. What is the covenant? And one can only decide that by construing the clause in its context. That's the point that we take.
Yes, very well.
So, my Lords, I'm just going to look at the principle of non-derogation from grant and the cases that we rely on in that respect first. Your Lordships have already been taken to Johnston and Holland. I'm going to take you in particular to Cabras, which follows on from Johnston and Holland, and that's tab 42. The particular page that I'm going to ask your Lordships to look at is page 980 of the electronic bundle. That's page 652 of volume 3. So, my Lords, the way that we interpret Cabras is this. The landlord has granted the tenant the right to use the premises as a licensed betting office, and for that purpose only. Now, what's not immediately apparent from the Court of Appeal's judgment is that the relevant clause, the user clause, was expressed in negative terms, so it was not to use the premises except for the purposes of a licensed betting office. So that reflects the position that we have in our case, where the clause is expressed in negative terms, but it was construed in Cabras to be a dispositive provision. So the landlord had granted the tenant the right to use the premises as a licensed betting office, and what Lord Justice Nurse was doing was construing the lease so as to permit them to maintain the signage advertising their business, because otherwise the business couldn't be carried on. So that was where the derogation from grant point came in. So, my Lords, looking at page 652 of the bundle, page 980 of the electronic bundle, about halfway down the page where the paragraph commences, Mr. Sparrow submits. So Mr. Sparrow submits that shows, so there's just been a reference to Wealden and Burrows and implied grants and a reference to the derogation from grant principle. Mr. Sparrow submits that shows that the court will, as a general rule, construe provisions such as clause 3 of the lease in the present case so as not to derogate from the grant made by the lease. That is to say, in this case, the grant made for the purpose of using the premises as a licensed betting office and for that purpose only. And we pray that in aid in particular, my Lords, because this is reflective of the position under our lease, where there's what's expressed to be in negative terms, but it's a grant, it's a dispositive provision.
But wasn't this the only permitted use here?
I'm sorry, my Lord.
Was this the only permitted use in this case?
It was the only permitted use, but there was a provision enabling the tenant to obtain consent to a change of use, but it was the only permitted use.
Well, that's different from ours, isn't it, where we've got various uses permitted?
We do have various uses, my Lord, but in our submission, there isn't a hierarchy within the permitted uses as to some of them aren't expendable just because the landlord would prefer not to have a change of use. Each use is explicitly granted, and the tenant is entitled to use the whole of the premises for any of those individual uses, we say.
But isn't Lord Conworth right? I mean, the permitted use here, a betting shop. Now, if the landlord starts seeking to prevent the tenant from advertising that this is a betting shop, then there's a derogation from grant. So isn't Lord Conworth to say that the wide user permission here is different?
Is different. Well, my Lord, as I've tried to explain, in our submission there isn't a hierarchy within the permitted uses. There are 5 permitted uses, but not to permit any one of them would be a derogation from the express grant. Because residential use per se, the whole of the residential use is being negated in the circumstances of this case. Now, if one were to have retail use as a broad use, the landlord may reasonably, possibly, object to a particular type of retail use within the broad retail use on planning grounds, if it wished to do so. It could potentially run that argument. But here, what's being explicitly negated is the entire use for residential purposes. There's no carve-out within that. So the tenant is left with 4 uses, whereas it had 5 before, and we say that is a derogation from the express grant to use for residential purposes. So, my Lord, just to continue with Cabras and the passage that I was looking at, Lord Justice Nurse agrees with the submission that's made by Mr. Sparrow here. The submission being that the court won't construe a general provision in a lease, particularly an exception, most of all an exception couched in very general terms, so to take away with one hand what's already been granted by the other in the dispositive provisions of the lease. So it's being treated there, as I say, as a dispositive provision, despite being expressed in negative terms. So, my Lords, we also rely on Said and Plus Trade. I will ask you please to turn to page 865 in the electronic bundle. It's tab 33 of volume 3, and it's page 537 of the hard copy bundle. So, my Lords, this is another decision of the Court of Appeal, and the tenant, Mrs. Said, she had a long lease, and it gave her the right in common with others to park on such part of the landlord's retained land as may from time to time be specified. And there was originally designated a parking area. The landlord took that away for 3 years while it carried out some work, and when it reinstated the parking area, it was substantially reduced. And the landlord argued that because it had the ability to specify an area from time to time, that meant it had the ability to vary and therefore reduce the area. And the Court of Appeal said, well, the power in the lease to specify a parking area didn't allow the landlord to withdraw that, and that would be a breach of the principle of non-derogation from grant. So, my Lords, as I said, can I ask you just to pick it up at page 537, hard copy, page 865 of the electronic bundle. This is paragraph 32, just at the bottom of the page on the right-hand side. Sir Christopher Slade is setting out the reasoning of the Deputy Judge there. And he says the right to park is in the nature of an easement. Well, whether or not it was an easement didn't actually matter for the purposes of the case. And the Deputy Judge said it would be at the very least exceptional if it were to be determinable at the will of the lessor. It seems to me that if the lessor had wanted to retain the entitlement to determine at his option the right to park, it was incumbent on him to say so explicitly, and he could easily have done so. And Sir Christopher Slade agrees with that statement. And over the page 538, or page 866, he goes on to deal with the way that the lease conferred the right to park. The parties clearly contemplated that this was a right that would be capable of being exercised. The function of specifying a part of the retained property for parking purposes was equally clearly conferred upon the lessor for the purpose of giving effect to that right, not for the purposes of enabling him to extinguish it. The subject matter of the grant of a right to park was not a right wholly determinable at the whim of the lessor. So then he goes on at paragraph 34 to deal with the well-known, well-established principle of non-derogation from grant, and he quotes from Johnston and from Cabras in that respect, and concludes at paragraph 36 that there was clearly a derogation from grant in that case because the right to park was entirely frustrated.
Did the Court of Appeal put this decision on the basis of a derogation from grant, Miss Scott?
Did they put it on the...
Yes.
Well, my Lord, what's being said at paragraph 36 is that it was a clear derogation from the right to park.
I'm so sorry. I meant in the decision under appeal. I'm so sorry. Didn't make myself clear.
Oh, I see. In the court below, was it put on the basis
In the
of
decision under appeal today. Was it put on
in
the
our
basis
case,
of
I'm so sorry.
derogation from grant? It's entirely my fault.
Yes, no, my lord, it was a point that I raised in my skeleton argument, both at first instance and in the Court of Appeal. It was recorded in the judgment of His Honour Judge Colander. It's fair to say that I didn't refer to Johnston, I didn't refer to Said or Cabras.
No.
But it was a point that I raised in my skeleton argument and in my submissions.
Well, you're leading on this now. Does that show some nervousness about the solidity of the basis of the decision in the Court of Appeal?
No, my lord, because we say that that is indeed how the Court of Appeal construed how the Court of Appeal reached its decision was by saying that this was in effect a rewrite of Clause 311. So that's essentially saying that that is a derogation from grant. You're trying to vary Clause 311 by removing one of the permitted uses. Now, it's fair to say that the Court of Appeal didn't express it in such terms.
No, okay.
But in fact,
That's what it amounts to.
I wasn't called on
Okay.
the Court of Appeal, my lord, so they only had my skeleton argument, and I wasn't called upon to give any oral submissions.
Very well. Thank you.
So, my lord, I'm going to deal with the arguments that were taken in my learned friend's written case against derogation from grant. Firstly, the point that there's no hierarchy of covenants. Now, in our submission, that's incorrect for the reasons that we've just explored. There is the principle of non-derogation from grant, and that ought to lead the court to construe, so far as possible, the lease clauses, in particular clause 319, to be consistent with the express grant. Because if the appellant's interpretation were correct, then that would have the effect of cutting down the natural meaning and effect of clause 311. So that would be a hierarchy of covenants in reverse. And there is no authority to support that proposition. I can at least point to authorities relating to derogation from grant to say we have here an express grant in clause 311, and what the appellant is trying to do is to derogate from that. But what Mr. Rainey's approach is simply to say, well, the reverse is true, but he doesn't point to any authority on which your lordships can rely in order to reach that conclusion. Excuse me. So, my lords, you will have seen from our written submissions that we do rely on other general principles of contractual interpretation, not just the principle of derogation from grant, to construe clauses 311 and 319 together so far as possible. Excuse me. We say that the terms of clause 311 are specific, but the consent requirement is qualified in general terms. It refers to reasonableness, and there's a general principle of contractual construction that the specific prevails over the general. And the terms of clause 311 are unequivocal. So whatever is reasonable could fairly be expected to depend on the other terms of the lease as a matter of contractual interpretation. And we also rely on the principle that the landlord here is the proferens. So clause 319 should be construed against the landlord, so far as it's necessary to do so. Clause 311 is part of a grant. Excuse me, I've got a frog in my throat. And the consent requirement is a reservation back to it. So there's a grant and a reservation back of the ability to consent to a planning application. And in our submission, construing a grant should require the reservation to be qualified rather than vice versa. And again, Mr. Rainey can't point to any principles of contractual construction that undermine those points. So, my lord, the point is also taken that this isn't a grant at all. Clause 311 doesn't operate as a grant, according to Mr. Rainey. He relies on the proviso to Clause 311 in that regard, saying there's no implied or deemed warranty that the premises may be used for the permitted purposes under the planning laws. Now, in our submission, our construction of the lease is supported by that clause. It's a clause that's designed to ensure that the landlord's protected from any argument that it's warranted that the premises can, as a matter of planning law, be used for the particular purposes, but the landlord's already permitted those uses as between landlord and tenant. So what the proviso to clause 311 is dealing with is the position of the tenant vis-à-vis public law, not the private position between the landlord and the tenant. Mr. Rainey also prays in aid the first limb of clause 319. This is it's a clause that emphasises that the tenant can't use the premises for the permitted purposes unless there is also permission to use those for those purposes as a matter of public law. So again, we say, well, as between landlord and tenant privately, clause 311 grants the permission to use for that purpose. What these other provisions are doing is to express the position as between the tenant and the local authority. There has to be, as a matter of public law, permission to use the premises for those purposes. And standing back, we say it would be most surprising to learn that there is an expressly permitted use under a user clause that doesn't in fact operate as a grant at all as a result of these carve-outs, these provisos. Because of the presence of a fully qualified covenant relating to obtaining planning consent elsewhere in the lease, it's not even contained within the user clause itself. What Mr. Rainey is saying that this permitted use is not in fact permitted at all until public permission has been gained for using it for those purposes, and we say that's the wrong way of looking at it. You've got to look at it privately between landlord and tenant, and as between landlord and tenant, the permitted use is permitted. It would be startling if the landlord could simply turn round and prevent the tenant from approaching the local authority in order to obtain the permission that it needs to turn them to residential use. I'm just going to deal briefly with the third argument that's taken against us.
You looked at the clock.
Yes.
We're in your hands, Ms. Scott. If this is a natural break, we'll break 2 minutes early and start 2 minutes early. But if you want to go on for the next 2 minutes, do so.
I will be very quick with this one particular.
Fine.
Yes. So what Mr. Rainey does is ask whether residential use is effectively prohibited. And we say, yes, it is. One must, of course, look at the circumstances at the time of the application. At the time of the application, residential use would be prohibited in its entirety for the duration of the lease or until there's a change in the enfranchisement legislation. That's Mr. Rainey's position. And there isn't likely to be a change in legislation for the foreseeable future.
Well, there isn't. The Law Commission are indeed looking at it at the moment.
Well, the Law Commission is looking at it, my lord, yes, but we say for the foreseeable future, one can't possibly say if and when there may be some change in the law. But in any event, our point is that the appellant's seeking to prevent residential use of these two floors in its entirety, and that amounts to a derogation from grant. The point is also taken that the ratio of non-residential use to residential use, if that were to change in future, then of course it would become unreasonable to withhold consent. And we say, well, that's a non-point. The landlord's effectively saying that these two floors can only be used for residential purposes if no other part of the building is in residential use. Whereas the grant of the right to use is the right to use the whole premises for the residential purposes. So what the appellant's seeking to do is to vary that provision and to derogate from the express grant. So, my lord, that's all I wanted to say on that topic.
Well, that's perfect timing, Ms. Scott. We'll resume the case at 2 o'clock.
Thank you.